James, you might need to put yourself on mute.
Okay, I'll try and find that mute.
Are we ready to start? Right. Good morning, everybody, and welcome to today's rather important Directions hearing. The hearing is going to be live streamed, subject to a 10-minute delay. Anybody who wishes to apply to have the live stream cut has that 10-minute gap in which to do so. Proceedings will also be not live streamed, where applications are made that parts of them should be heard privately. Mr. Barr.
So I appear today on behalf of the inquiry with Ms. Hemingway and Mr. Salisbury. Ms. Heaven appears on behalf of the non-state core participants. As you know, she has provided a clear and helpful note setting out the NATE core participants' general position, and that will be published on the inquiry's website. Ms. Johnson appears on behalf of clients represented by Bernberg Pierce. Ms. Dayton on behalf of clients represented by Dayton Pierce Glynn. Mr. Greenall and Ms. Lewis on behalf of clients represented by Hodge Jones and Allen. I understand that Ms. Al-Shakili is attending in a non-speaking capacity in respect of those clients represented by Imran Khan and partners who rely on their written submissions. Ms. D'Agostino appears on behalf of clients represented by Kellys. Mr. Scobie, King's Counsel, on behalf of clients represented by the Public Interest Law Centre. Mr. Morris and Ms. Steele appear as participants in person. The purpose of today's hearing is to consider a number of applications for extensions of time in which to respond to the inquiry's Rule 9 requests for witness statements from non-state, non-police core participants in Tranche 3. You will also wish to clarify with the relevant advocates or participants in person, as the case may be, the positions of those who have received a Rule 9 request for a Tranche 3 witness statement and whose names appeared on an open letter sent to the inquiry by the campaign opposing police surveillance before deciding how to respond in each case, noting that only those signatories who have not subsequently regularised their position by agreeing an achievable deadline with the inquiry legal team will need to be heard. On its face, that letter threatens the deliberate withholding of evidence from the inquiry by named individuals and groups. I should make clear that our starting point is that the inquiry wants the evidence that we have requested. The voice of civilian witnesses is important in our mission to get to the truth. No one who listened to their evidence in our evidential hearings to date could be in any doubt about that. However, the inquiry's terms of reference require you to report as soon as practicable. You also have a duty to act fairly. In practice, this means that the inquiry must afford the recipient of a Rule 9 request for a witness statement a reasonable time in which to respond, a period which may vary according to the circumstances of each individual concerned, but no more time than that. This is because delays in the provision of witness statements will delay preparation of the T3 hearing bundle and, if great enough, threaten the T3 start date and the date by which the inquiry can report. Unjustified delay on the part of one participant is not fair to others. The October 2025 start date for tranche 3 may seem far away. It is not. We will need to release the hearing bundle, or at least substantial coherent parts of it, in early July, 3 months before the start date, if people are going to have the time they need properly to consider what will be a very large quantity of evidence. Privacy restrictions need to be applied and final checks conducted in relation to many thousands of documents before they can be added to the hearing bundle and released to core participants. This takes time, especially because it is important that privacy rights are properly respected. Determining what should be redacted is not always straightforward, especially where very private evidence is also of great evidential value. Witness statements and privacy applications, provided as soon as they reasonably can be, are essential for this process. So I understand that you wish to hear from the advocates sequentially, hearing in each case their submissions in respect of each of their clients' outstanding applications. Ms. Johnson, for Bernberg Pierce's clients, will be first.
Thank you. Today, we are concerned with two dates. The first is the date by which applications for privacy redactions on those documents that have been produced by the inquiry must be determined. That date is fixed. It is the 11th of April. Any applications of that nature which are not received by the 11th of April will mean that privacy redactions over those documents in relation to the relevant individual will be determined by the inquiry. The second date, and that which is going to be the subject of submissions today, is the date upon which witness statements requested by the inquiry from individuals are to be provided, together with any exhibits or other documents that the individual may wish to produce. Like Mr. Barr, I welcome the participation of individuals in the inquiry. I acknowledge, as he does, that it is an essential part of our process. But as he points out, time is not unlimited, and to enable the inquiry to be conducted and for me to produce a report based upon the evidence which I will by then have considered, things must be done on time. Today, dates are going to be fixed. This is not an occasion for a general discussion about time limits or other issues. It is a date upon which decisions are going to be made, and subject, of course, to those circumstances which are exceptional and, I emphasize and, which cannot now be foreseen. The dates fixed today will be the dates upon which events must occur. As Mr. Barr indicated, we're going to hear applications in the order of the firms who have made them, and then the two participants in person at the end. I invite Harriet Johnson to make the first submission.
So I'm perfectly happy to begin my submissions, but my understanding was that Ms. Heaven had some general submissions she wished to make first. I just wanted to clarify whether you wish to hear from her before me.
As I've indicated, dealing with dates. I will hear Miss Heaven when she makes submissions on behalf of Kelly's, but I do want to hear the submissions of those who apply to have specific dates set, and I wish to do so in the order in which they're set out. And so I would invite you to start.
I'm grateful, sir. So I can begin by talking about specific dates, and then I can give some reasons in support of my application. If I can do it in that way, it may assist.
Yes.
So the deadline currently in place for the statement of Helen Steele, and forgive me, I ought to say Ms. Steele will address you separately in relation to her submissions on McLibel.
Yes.
So I won't deal with those. The deadline currently in place for Ms. Steele is the 4th of April. The extension sought, and I ought to say at the outset, sir, all of these extensions, all of these dates have been carefully considered and are, in the view of those who instruct me and of our lay clients, the earliest realistic date by which these statements could be provided. The date Miss Steele seeks is the 6th of June. For Ellie, the current deadline is the 24th of March, and the extension sought is until the 28th of April. For Lindsay, the current deadline is the 19th of March, so tomorrow, and the extension sought is until the 14th of May.
Yeah.
So you will have seen that although other category H core participants are mentioned in our submissions, no formal application has been made yet by those women who continue to work towards their statements and make no application at this day.
Well, forgive me, dates are going to be fixed today for everybody.
So may I await instructions from my solicitors on those points then, and continue to address you generally as to reasons.
I am bluntly less interested in general reasons than I am in practicalities relating to individuals.
So yes, when I say general reasons, I mean that there are some circumstances, of course, that apply to all of these participants, rather than repeating them for each woman.
Forgive me, what I am interested in doing is in setting dates for each individual. It is not helpful to have general applications without the end date being in mind.
So then my instructing solicitor informs me that she'll provide those dates very shortly. Perhaps I can...
So what is meant by very shortly?
Well,
today is the day
yes.
on which dates are going to be determined.
So yes, during the course of this hearing.
Forgive me, if you're not able to advance submissions for all of the individuals that the firm who instructs you represents, then I had better, I think, start with someone who is in a position to deal with every individual that their firm represents.
Very well, sir.
Forgive me, I don't mean to be discourteous, but unless we do these things systematically and in detail and by reference to each individual, we're not going to make progress. Then can I put you back to enable you to get the instructions from your solicitors about the individuals, and would you let the inquiry team know when you're ready to proceed?
Yes, sir. Thank you.
Thank you. In that event, I think we next then proceed to Miss Dayton.
Good morning, sir. Thank you. My application is on behalf of Dwayne Brooks.
Yes.
He applies for the inquiry to ask him to submit his R9 statement by May the 8th. So that is 12 weeks from the date of service of the R9 request. The reason for this application, sir, is simple. Mr. Brooks is unable to provide a statement addressing 15 years of traumatic, eventful occurrences from the time that he was a teenager within the original deadline. To use Mr. Barr's words just now, that is simply not achievable. So there were written submissions dated 14th of March. Could I just check that you do have those?
Yes, I do.
Then if I may, I'll take them through you very briefly. So the reasons fall into various categories. The first is the scope of the R9 request. It's far-reaching and very demanding of Mr. Brooks. In terms of time, as I've said, he's asked primarily only to address his experiences between 1993 and 2008, a 15-year period, a very long period. In terms of the quantity of disclosure from the inquiry, he was provided with a large number of documents, 267, many of which were multi-paged, or most of which were provided only on the 20th of February. In terms of the issues, the questioning from the R9 deals with a large number of very different types of occurrences. The most general and demanding is perhaps his involvement in, and I quote it, challenging state misconduct and anti-racism activism, focusing on these same 15 years, and to detail his involvement with any groups that fall into that description. He's asked also, by way of another example, to give details of his relationship with 7 individuals. Some of those relationships are very long-standing and very complicated. He's asked also to deal with a number of false criminal allegations against him. In terms of his own documentation, sir, he's asked, as you know, to provide documents that he considers to be relevant to these questions. He, of course, will want to do that, but it's also particularly necessary for him to research and identify relevant contemporaneous documents, because this period starts not only when he was a teenager, but when he was a teenager suffering from chronic post-traumatic stress disorder. Both factors, as you know, sir, affect memory. It is essential for him to be able to give the best evidence to have access to relevant contemporaneous documents. And so it matters, but to give you a sense, these will be contemporaneous notes and documents from the Lawrence inquiry, from Hearn, in relation to each criminal allegation, in relation to each meeting raised by the inquiry, in relation to the ongoing investigation into the murder of Stephen Lawrence and attack on Mr. Brooks, and in relation to each of those meetings that took place. As you'll know, sir, one of the figures of this inquiry was the covert recording of a meeting between the then Assistant Commissioner, John Greaves, Mr. Brooks and myself. We can't name them. The scoping has only just started, but we do know that our firm has a considerable number of documents that need to be accessed. So the next factor is the solicitor taking the instructions. I consider and would urge you to accept that it would be very counterproductive, slow and time wasting for anybody other than myself to take these instructions. So I have knowledge of many of the events, I have knowledge of the individuals, and I understand better than any other lawyer the context of many of those occurrences. It would be quicker and cheaper for the inquiry to allow me the time to do that work. Secondly, it would save the re-traumatization, which is likely if Mr. Brooks has to explain the context of each of those occurrences to somebody who's not familiar with them. And I go into that in some, perhaps too much detail for you, sir, simply for this. The request for the R9 came the day I went on leave. And so in effect, my time working on this R9 started last week. So we lost 3 weeks. The other aspects are that in itself is an immense amount of work, but we are hindered, and it's maybe something that you would be able to address. We're hindered by the way in which the EPIC system works or doesn't work. To give you some examples, as you'll know, we're not permitted to download from that system. So in practical terms, what that means is, for instance, preparing the written submissions to you, sir, I had to copy type bits from the R9 statement rather than cutting and pasting. I mean, it must be a nonsense, sir. And also, it might be worth addressing the logic of it, because when we are preparing the R9 statements, we are going to be referring to the documents. We are going to be referring to the contents of those documents. So they will be in Word format in any event. So the prohibition on downloading merely delays the transfer of the content of those documents from EPIC to Word. And it would speed things up immeasurably if we could download. The other aspects is we could group the documents together in a way that makes sense to take instructions. We could write comments on the index rather than having to copy type the documents. And it would save us from another very time-consuming problem, which is that although we can, as you know, do annotations on the documents on EPIC, the annotations sometimes just get deleted, and we're not permitted to download those documents anymore, the annotations anymore, which is a change from tranche 2. So those are the problems we face, and those are the difficulties we have. And we don't see them as insurmountable, but we do know that it's going to take a long time. But in closing, I would like to make 2 positive points. The first is this: Mr. Brooks wants to participate, and he wants to provide the best evidence as he can, as soon as he can. Our estimate is an estimate because, as I've made clear, we haven't yet got stuck into the scoping work. The second positive thing, so, is this: it's the empathetic way you addressed the timing for my client, Mr. Richard Adams, to give a statement. The way you addressed it enabled Mr. Adams to take his time to provide a full statement and to source contemporaneous documents and disclose them to you in a way which I think was helpful to you. And you kindly told him at the end of his evidence that you were impressed with it. So Richard Adams gave impressive evidence because he's an impressive person, but he could only do it because he was not under great pressure. He had no pressing deadline from you. And what that meant, sir, was that when he felt able, he could go up into his attic and delve into documents that recorded traumatic events in his past. When he felt able, he could come to my offices to give me instructions. And when he didn't feel able, he felt fine, as did I, to say, sorry, Jane, I'm not coming in. I can't do it. I can't face it. So you gave him time to consider in depth the inquiry's disclosure to him, and, as I've said, to source, but also to consider the documents that he unearthed from his attic. Mr. Adams was respected, and he had some control over the process. And so this application is, in effect, asking you to give Mr. Brooks the same opportunity. Unless I can help you further, sir, those are my submissions.
They are very helpful. I'm going to pause momentarily because I want to take instructions, if I can put it in that way, about the downloading issue, which I know has been a problem. I hope it is capable of resolution. I know that I do not fully understand it, and it is better, therefore, if I am informed about it now before I respond to you.
Thank you, sir.
Then we'll pause momentarily. The live stream will be cut while I go and talk to my people. Could Miss Dayton be invited back, please?
Sir, I'm here.
Ah, you are. Forgive me, I didn't. Your face was not on the screen, and I was not aware that you were there. Qualified good news. First of all, as far as downloading goes, what the inquiry is doing is inviting those who wish to download to apply for permission to do so. It has been granted in other cases. I'm told that there is no reason apparent at the moment why it would not be granted in your case as well, so that that aspect of the difficulties that technical difficulties you're experiencing, with luck, will be removed. Secondly, I am told, although I don't begin to understand it, that cutting and pasting can already be done without a problem.
Well, that's two pieces of good news then, sir. Thank you.
Now, the third and more qualified piece of good news is this. I do acknowledge the very great amount of work that has to be done, both by Mr. Brooks and by yourself, and that I do acknowledge that the original date is too soon, but I cannot postpone it as far as the 8th of May. What I'm perfectly happy to do is to require the witness statement and any exhibits to be provided by Friday the 2nd of May. That undercuts your request by a week, but by no more than a week.
Thank you, sir.
I trust that is acceptable. That is the decision.
Thank you.
Next, I think it is Mr. Owen Greenall and Ms. Lily Lewis, provided, of course, that Ms. Johnson has not yet got fully instructed, which I anticipate she will not have been. Could Mr. Greenall and Ms. Lewis be put on the screen, please?
Sir, I hope you can see and hear me.
Yes, I can.
Thank you. I hope also that you've received two documents. One is a general document with submissions filed on the 14th, and the other is a document with personal individual matters that was filed yesterday.
Yes.
I'm grateful. In terms of the general applications, I will make some general points, and then I will be dealing with the specific individual circumstances of Mr. Ben Leamy, and also Reclaim the Streets and Paul Gravett, and Ms. Lewis will be dealing with the other clients.
Yeah.
In terms of the cases in general, those instructing me ask for an extension of time until the end of April for all the clients that they represent. We set out in our document at paragraph 8 the nature of the difficulties which our clients have had in completing the Rule 9 requests. There are in many cases a large number of documents. They are also individual work commitments, health commitments, and the like. They have also, a lot of them have psychological issues in engaging with the material, which requires a careful engagement with the material. We have set out in writing our general submissions, and we also adopt and support those submissions made by Ms. Heaven in relation to, on behalf of the non-police, non-state participating group. That is in relation to the general application. In terms of the individual circumstances, if I might deal firstly with Mr. Leamy, we have set out in writing in the document provided yesterday the chronology of the applications which have been made already on his behalf, and the difficulties that he has had in accessing the material. He made an application to be able to download. That took some time. That has been granted, but took some time to do so. It was necessary, given the nature of some of the questions and material disclosed, for him to re-engage solicitors, having initially being representing himself. So there have been a series of applications made, so far, those applications have been refused. And so on his behalf, for the reasons effectively set out in writing there, I seek an application until the end of April. In relation to other clients which I represent, as I indicated, I seek a general application for until the end of April. In relation to two specific clients, I seek a further extension until the end of May. Those two clients are Reclaim the Streets and Paul Gravett. In relation to Reclaim the Streets, there is a very large amount of material. There are also a large number of individuals who are contributing to the Rule 9 statement on behalf of Reclaim the Streets. The statement covers a large period of time. It's not possible for one individual to cover everything themselves, and it needs input from everyone. And so on that basis, I seek a longer extension. In relation to Mr. Gravett, again, he has a significant volume of documentation. He also has significant work commitments. So you may recall that in tranche 2, Mr. Gravett was required to come back on a second occasion to complete his evidence. That has already disrupted his work commitments. He's keen to engage with the inquiry, but obviously it has a knock-on effect. So those are my submissions in relation to the individuals and the wider clients that I represent.
Deal with Mr. Leamy first. He apparently made it clear that he would not contemplate providing a witness statement unless a raft of further documentation was provided to him. What's the status of that?
In terms of, well, he wishes to have disclosure of that further material in order to complete his statement, and he maintains position that it is relevant to his personal statement. His position is that he will review the position following this hearing on his ability to comply with the Rule 9 request.
May I make it clear that he has been provided with the documents that the inquiry has, which it considers relevant for him to see, and there is not going to be any further disclosure exercise to him. I say not going to be. There are always occasions which arise for a wide variety of reasons why a tiny handful of documents might be disclosed, but he must not assume, please, that any further documents are going to be disclosed to him. On that basis, what is his application?
So my instructions are that he seeks an extension of time until the end of April to provide the statement.
Why does he need an extension until the end of April? He's not provided us with any reasons beyond the demand or the request that he sees further documents.
So in my submission, he had the request for further documentation is not the only basis of his request. There has been a significant amount of time lost in terms of his accessing the material. There were difficulties with the EPIC system, as Sir has already heard. He was required to download material. It took time for that, considerable time for that request to be granted. There was a need to re-engage solicitors, given some of the material that was disclosed to him. That caused a delay. He also has work commitments and has been traveling abroad for work for part of the period during which his statement was required. So he has made in-time applications for extensions. The current, given if one takes account of the general extensions granted for issues with EPIC and for documents which have been provided to him, that the 6 weeks from then actually takes him up to the end of this month.
Yeah.
So that even on that basis, the standard 6 weeks would take him to the end of this month. He seeks and makes an application until the end of April because he requires further time to comply. But it's not simply on the basis that he needs the additional documentation requested.
Well, what is the reason why he requires until the end of April?
He needs to deal with the allegations made and issues contained in the Rule 9 requests. He needs time to do that, to go through the material and to prepare his statement. What Mr. Leamy and all my clients wish to avoid is dealing with matters piecemeal, not being able to provide a single statement which deals with the vast majority of issues in the round. And that's what he requires the time for.
He's had the documents now for 9 weeks. He must be in a position to be able to provide his evidence in the near future, not in the middle term.
You have my submissions, even taking into account, from the date that every document became available to him, and he was able to download in the rest. That takes us up already until the end of March. So it is not the case that he's had access to everything up until this point.
I intend to raise the points that you have raised with me with the inquiry team, and so this is likely to be something that happens every time I hear submissions, that there will have to be a pause while I briefly discuss things with the inquiry team. But I have your submission on Mr. Leamy's behalf. Now, Reclaim the Streets, you say that you want until the end of May.
Yes, sir.
Now, that causes potentially serious problems for the inquiry. I acknowledge that Reclaim the Streets has a lot of documents produced to it, but they have been, I think, produced now for some time. Let me check. Yes, you've had them for 4 weeks. The standard request that have received has been for a period of 12 weeks from date of receipt of documents, which takes us to a date significantly earlier than the end of May.
Well, if it's 4 weeks to date, and then a further 8 weeks, would be 12. It's not so far from the end of May. I accept that we are asking for a bit more time, but clearly when there is a corporate statement that is needed to be produced, particularly when there are a large number of persons contributing to that, and there's no one individual or core group of individuals who have temporal continuity throughout the period, there is going to need to be further time required because different eras, as it were, are addressed by different individuals and different groups. So it is the combination of the volume of documentation and the number of persons present involved that forms the basis of, we say, the exceptional circumstances that are needed for the extension of time sought until the end of May.
Forgive me, the documents were provided on the 21st of February. 12 weeks from then does not take us to the end of May.
No, I accept that, sir. Yes, I wasn't saying that it did take us to the end of May. It takes us until sometime towards the end of April. My point was that it's looking at matters in the round. It is a significant but not, in my submission, disproportionate extension to the end of May, given the particular factors relevant to that group.
I am at the moment minded to extend until the 2nd of May, but not the end of May. I believe, from all the basis of what I've been told, that extensions until the end of May will throw out the process of preparing for the hearings in a manner that simply cannot be accepted. Mr. Gravett, him. The same timeframes apply to him as well, both date of service and the comments that I've just made. Is there any, I assume there's nothing further that you wish to add on his behalf?
No, sir. No.
Right.
Thanks.
Then I will either hear from your colleague or break momentarily now. I think it is probably better that I hear from Miss Lewis before returning with a decision. Ms. Lewis.
Thank you, sir. I make representations in relation to a number of core participants represented by Hodge, Jones and Allen. I'll break those into two groups. Firstly, core participants associated with Movement for Justice, and secondly, what I'll refer to as family campaigns. Dealing first with Movement for Justice, so as you set out in your determination on CP status made in 2018, MFJ was and is a campaigning organisation founded in 1995, which participated in several campaigns, which were the subject of reporting by SDS officers. 4 core participants that we represent were founding members of that group: Antonia Bright, Karen Doyle, Tony Gard, and Alex Owolade, the latter of whom has been designated as the spokesperson for the MFJ statement for the inquiry. It's clear on the disclosure to date, totaling around 350 documents, that MFJ were subject of detailed and persistent reporting by the SDS. This has meant that a large amount of time and careful consideration is needed in order for the CPs that we represent to consider the large volume of documents that has been disclosed in relation to the group, and also for them to comment on collectively and individually. Now, I stress at the outset that given the emphasis placed on the group by the SDS in the context of its overall surveillance of family justice campaigns and police monitoring groups, evidence from these individuals and the group itself is absolutely essential to the inquiry's analysis for the justification for and proportionality of such monitoring. And in order to conduct a full and fair investigation into the deployment of officers in these groups, in my submission, it's absolutely essential to hear from these 4 core participants and from the group as a whole. So I've set out in some detail in the schedule to our submissions the personal circumstances that are relevant to requests by these CPs for an extension of time. Given the personal and sensitive nature of some of those factors, I don't intend to go into detail into those circumstances. If you'd like me to, sir, I'd request that is done in a private session, but I can certainly outline the dates by which those CPs expect that they can comply with the request for a Rule 9 statement.
Yes, I think the sensible method of proceeding would be for you to
apologies.
identify dates.
Apologies, there was a brief issue with my sound. I can hear you now.
Good. Let me start again then. I think the sensible method of proceeding is for you to indicate to me the dates upon which individuals request to be able to provide a witness statement. And then if we do need to go into private session, we'll do so then, but it may not be necessary. Let's see.
I'm very grateful, sir. If I can begin with Miss Bright.
Yes.
I'm instructed that she'd be able to comply with the deadline for a Rule 9 statement by the 5th of May of this year. Miss Doyle by the end of April. Tony Gard by the end of April. Mr. Owolade, in light of the volume of both personal disclosure and disclosure to the group as a whole, and his role in providing the Rule 9 statement for the group, would request the 7th of May of this year. And for the group as a whole, by the end of May.
Yep.
I think so. That covers all the CPs associated with Movement for Justice.
Yes.
Then turn on to family justice campaigns, if that would assist.
Yes, certainly would.
I'm grateful. As we set out in our written schedule, and for reasons that, again, due to their sensitivity, I won't address in this open hearing, MSW has made a number of requests to the inquiry for a meeting. The reasons for that request were explained in emails to the inquiry legal team on the 12th and 18th of February. Now, I summarise in my written schedule subsequent correspondence that took place in relation to that request. And it's now understood that a meeting between MWS's legal representatives and the inquiry legal team has been postponed to the 21st of March. As I understand it, a meeting between MWS and the legal team has not yet been set. In light of the need for that meeting and the need for the inquiry to take a trauma-informed approach to these procedural decisions and its engagement with core participants, we would ask for a deadline for both MWS and MSS of 10 weeks following that meeting. Again, sir, if I can assist on further details relating to that request and the personal circumstances of those two CPs, I'd ask to do that in a closed hearing.
Indeed. I think that both MWS and MSS need to understand that if they wish to participate in the inquiry, that it is not acceptable to say we have to have explained to us personally and in detail aspects of the inquiry's procedures. My understanding of the situation at the moment is that the solicitor will discuss with the inquiry team next Thursday. That's to say, get my dates right. On the 20th.
I think the date I had, sir, is the 21st, but you might.
But I think you're right. I think it is Friday. It's Friday the 21st. You're right. Thank you for correcting me. There will be a discussion with the inquiry legal team and the solicitor for MSS and MWS. My current view is that unless by 4 p.m. on the following Monday, that's Monday the 24th of March, MWS and MSS indicate unequivocally that they intend to provide a witness statement to the inquiry, what will then happen is that they will be invited to submit within 4 further days, that's to say by the end of the week, why it is that their designation as core participants should continue. I'm afraid that the inquiry cannot proceed on the basis that individuals can demand what has been demanded by MWS and MSS, and then a further lengthy extension. It is not acceptable.
So that's noted. I know that the coordinating group referred the inquiry in its written submissions to the government guidance on taking a trauma-informed approach. I just note very briefly that guidance includes principles such as asking individuals what they need and collaboratively considering how these needs can be met. I know that both core participants under consideration have experienced quite unimaginable trauma, and I know that the inquiry has committed to taking a trauma-informed approach. In my submission, that meeting offers an opportunity to put these principles into action and would allow the inquiry to understand how a flexible and trauma-informed approach can be taken to ensuring that both core participants are able to participate in this inquiry and for their important evidence to be heard. I note the comments you've made in relation to these applications, and it may be that a further application for an extension can best be addressed following that meeting.
I intend to set a date for the receipt of their witness statements if they're going to submit them. But I have made it clear that there is a step to be taken in advance of that, which may have consequences which mean that the inquiry will not be able to receive their evidence, or may, and I hope it can be, result in the setting of a date with which they can comply, which fits in with the inquiry's timetable. But I'm afraid we are here for making decisions rather than for expressing views about how, in the perfect world, things should be done.
In light of those comments, then it may assist for me to briefly address the 2 remaining core participants who fall under the bracket of family justice campaigns and the request for an extension in relation to those 2 CPs.
But before we get to that, can I understand the date by which, if MWS and MSS are going to provide witness statements, they request to do so?
So as I set out, my instructions are to ask for 10 weeks following that meeting. In light of your observations, we would ask for the end of May. And that's on the understanding that the meeting scheduled for next week will indeed take place.
Scheduled for this week, it's Friday the 21st.
Apologies, the end of this week, sir, thank you.
Right. Very well, I've got the date. Yes,
I'm
now,
grateful.
2 others now.
The 2 remaining core participants on which I seek to address you are Devriel and Tishreel. Similar considerations in relation to the requirement for a trauma-informed approach apply to them as they do to MWS and MSS. We've set out some general observations in relation to the need for more time for those core participants for whom reviewing disclosure is particularly emotionally distressing in our written submissions, so I won't repeat those considerations now. Devriel and Tishreel would similarly ask for the end of May of this year in order to comply with the request for a Rule 9 statement.
These dates are later than those canvassed before in correspondence. What's the reason for that? I mean, what has been set out in documents that I've received is we want until the 30th of April.
So in our general submissions, we set out a general starting point. I address you on these core participants in particular because they have exceptional reasons necessitating a later deadline, particularly the trauma that they've experienced and the difficulties in reviewing sensitive disclosure. Given indications made by the inquiry, we've taken time to consider realistic deadlines that can realistically be complied with in order to try to avoid the iterative process that's taken place so far, which has involved multiple requests for short deadlines, which is, of course, onerous not only to core participants and their legal teams, but also to the inquiry team. And it's with that need for a realistic deadline in mind that I make that request today.
Okay.
That I think completes all of the core participants that we, instructed by HJA, wish to address you on, sir.
I'm sorry, you may wish to address me only on those. Does that mean what is to be said about all the rest? Are there any applications?
In relation to any other CPs, for the reasons that we set out in our general submissions, we would ask for a deadline of the end of April of this year. And would rely on reasons given in existing extension of time applications made by Hodge, Jones and Allen.
But I'm afraid that is not acceptable. The individual circumstances must be addressed. And I am perfectly happy to extend some to the end of April or 2nd of May. Time difference doesn't matter greatly. But I am not prepared to do it on a blanket basis. And I have had no individual reasons advanced for why individuals require that length of time.
So it was our understanding that you would be assisted by being addressed on 7 particular cases set out in our schedule. Individualised applications have also been made in relation to other core participants and the requirement for an extension of time. Those personal circumstances are addressed in those individual applications made by HJA.
Then I suspect that we will have to have a private hearing while you address those issues. But are you in a position to do so?
Yes, between Mr. Greenall and I, we can certainly address you. Apologies, sir. If I can perhaps just turn briefly to my learned friend.
Of course. Yes.
So I'm very grateful for that time. Our general submissions apply in relation to the group as a whole. So if you require further information about core participants other than the submissions made already today and those contained within our schedule, then we will need to provide that separately.
Well, you'll have to do it today. I cannot avoid re-emphasizing that today is a day for making decisions. I am not prepared to make general extensions of a kind which make the preparation of the hearings beginning in October problematic.
That is well understood, and that information can be provided today following this hearing.
No, it is to be provided at this hearing. I cannot but emphasize that today is a day for making decisions, not we'll decide it later. Dates are going to be set today, and I therefore need to have today submissions made in relation to individual dates.
That's well understood. But I think Mr. Greenall is going to very briefly address you.
Mr. Greenall.
So you may have realised I'm sitting in the same room as Ms. Lewis.
Yeah, of course, yes.
In relation to the other clients that we represent, obviously there are a significant number, and this hearing has come on at quite some pace. We will endeavour to take whatever instructions we can about individualised circumstances beyond what is contained in the written submissions that you already have, sir. And our solicitors will endeavour to do that whilst this hearing is in progress. Given the timescales, that is all we are in a position to do to make individualised submissions beyond what you have in writing.
I am going to break now momentarily to deal with the specific requests that you have addressed in relation to individuals, both you and Ms. Lewis, and we will return to those where you have not made individual submissions later on in the day, so as to give you time to take instructions.
I'm grateful, sir.
That helpful? Good.
Thank you.
Then we'll pause momentarily.
Please begin whenever you're ready, sir.
Thank you. Mr. Greenall, Miss Lewis.
Yes, sir, we're here.
Good. I'll deal first with the position of MFJ and those who participated in MFJ, including Mr. Awolade, for two reasons. First, the importance and difficulty of the task, and secondly, the personal reasons relating to two of the individuals, which are set out in the material that has not been made public. I will extend the time for submission of the Rule 9 statements for all of those concerned in MFJ. That's to say, Antonia Bright, Mr. Doyle, Mr. Gard, Mr. Awolade, and MFJ collectively until the 9th of May. That's Friday, the 9th of May. I cannot do it beyond then because otherwise it will throw out the preparation of hearings which do have to start on the scheduled date in October. As far as the reels are concerned, they originally sought an extension, I think, until the 30th of April. I'm perfectly happy to extend until the 2nd of May, Friday the 2nd of May, but not beyond. And that is the date by which they will be requested to provide their Rule 9 statement. As far as MSS and MWS go, if they are going to provide a statement, and as I've indicated how that issue is going to be approached, then the date for the provision of their statements will likewise be the 2nd of May, Friday the 2nd of May. Mr. Leamy has created a number of problems for the inquiry, not least that he has recently, it is said, breached the terms on which he could download documents from the EPIC platform, which means that he may not have had access to all of them since. There are 3 documents concerned, but I'm afraid that the time for him to provide his witness statement in cannot be extended for the amount of time that he seeks. The issue about the supposed breaching of the terms on which he could download documents needs to be discussed by me momentarily further before I set the final date for the receipt of his witness statement, but it will not be of the length indicated for others.
Understood, sir.
Now, you're going to come back later on in the day about the other individuals, you're not?
Yes, sir, we're endeavouring to do our best.
Yeah, of course.
There's been some miscommunication about exactly what was required, but we will certainly make whatever submissions we're able to. Thank you.
Thank you very much indeed. Then the next submissions are to be made by Mr. Agostino, I think, are they not?
Morning, sir.
Good
So
morning.
I make these submissions on behalf of discrete core participants in the absence of Pete Weatherby and Hannah Webb, who are unable to join the hearing and send their apologies. We've put in written submissions on behalf of Emily Apple, and I want to briefly address you in relation to 56A InfoShop, because I believe there's been some confusion in relation to that civilian group, but I'll deal with each one in turn. Emily Apple has a current deadline of the 28th of March. The main problem that we have in relation to accessing material is difficulties around EPIC. Miss Apple works 4 days a week and has significant personal issues, some of which, if you need me to address you further on, we can move to a closed session. She only is able to work on her reviewing documents and tagging and annotating at weekends. We've lost 2 weekends due to issues with Epic, and I believe 7-day extensions were granted to everyone in relation to those issues. But Epic was also down this weekend, which hasn't been factored in.
Can I interrupt you there? Yeah. Because my understanding and yours is different about what happened this weekend. My understanding is that on the first occasion when there were problems with Epic, it wasn't indeed resolved until Monday. But on Monday, Epic made it clear that they had a 24-hour help service, and that if for any reason the system did go down, they were available to put it back up, so that the second incident, the second weekend difficulty, should not have been experienced. This last weekend, the 15th and 16th, there should not have been any problem at all, and I do not understand there to have been any problem.
Well, certainly it was posted on Epic that it was down for maintenance from 5 p.m.
Yeah, quite, but not for the whole weekend. Only for
not for the whole weekend. But core participants only have a limited time to work on their statements and access the material. So there have been difficulties, and special measures have been granted to assist.
Hold on a moment. I quite appreciate these technical problems do occur, but they should not be overstated. And if all that happens is that on Friday evening, or Friday early hours of Saturday morning, as I understand it, the system is down for maintenance for a couple of hours, then that doesn't create a real problem. And it is, I think, not sensible to submit that it does.
Well, only that Miss Apple has that her time frame to be able to work on this material is at weekends. And if a notice comes up saying Epic is down on Friday from 5 p.m., that is the window in which she would normally be working. We don't wish to overstate the problem, but there have been ongoing issues, including her getting access to material, and also issues around being able to annotate the material she was previously, on one occasion she was able to do it, and then subsequently she was not able to do it. So there have been issues with annotations. The main problem we have is commitments with working, family commitments, assisting with the estate of a deceased family member, and personal issues which have been addressed in previous correspondence and which are touched on in our application, which was submitted in writing. We do expect further exhibits to be coming. We seek an application for an extension of time until the 30th of April, but I just wanted to touch on the privacy.
Forgive me, I may be able to cut you short, because I am perfectly happy to extend until the 2nd of May.
Thank you, sir. But what I did want to just touch briefly on is, I note that the hard line in relation to the 11th of April for the privacy redactions, we would obviously, if any associated application must be over for privacy redactions over her own material, that includes exhibits and her witness statement, must be submitted and pegged to that 2nd of May deadline. And I don't know that that's been considered, but the original our information from the inquiry was that all privacy redactions had to be submitted by the 11th of April, whether that was over your own witness statement or not. Clearly, that needs to be needs to be pegged.
Let me make the position perfectly clear. If I didn't when I made opening remarks, the inquiry requires privacy applications over the documents that it has disclosed by the 11th of April. Plainly, it cannot require, by the same deadline, privacy applications over a witness statement, and for that matter, documents provided by the witness on the 11th of April. They can only be made when the witness statement and any documents accompanying it are provided. That's readily understood.
Yeah, okay, just wanted to make that clear because...
Yes, well, then thank you for giving me the opportunity of making it clear, and I hope it is now clear.
Thank you. So the issue in relation to 56A InfoShop is slightly more complicated. An application was made for core participant status several years ago in 2018. The inquiry ruling that covers this, which it's ruling number 42, refers to an application being made on the 5th of January 2024, which is not the case. The relevance of this is because although 56A is not core participant status, there are two core participants within 56A represented by a different firm, and a third civilian who is under the umbrella of 56A InfoShop and has not received a Rule 9 request. It seems that 56A has had disclosure through me, and all the three core participant stroke civilians have had access to that material. But the Rule 9 request has gone to a different firm in relation to one core participant and is included in the questions in relation to another core participant. This Rule 9 request in relation to Carolyn Wilson was only sent to her on the last Thursday or Friday, I believe. I haven't seen it because it went to a different firm. I would ask that we have time to resolve this with the inquiry, as it's clearly a little bit more complicated given the backstory of how this has come about, with different people having access to the disclosure than those who've been sent the Rule 9 request. So I would ask for the 30th of April to resolve this so that we can liaise about a way forward, because I understand that Carolyn Wilson has been sent the Rule 9 with a deadline of very early April, which is in addition to other statements that she has to submit personally and contributing to the Reclaim the Street statement. So while this issue is resolved, I did want to make a request for an extension of time while we look into the issue, because obviously if I have access material, then I need to liaise with the other lawyers, and likewise they have the Rule 9 request that I haven't seen in relation to the people they act for. So slight confusion. It dates back to an original application dated 2018, which the inquiry has indicated was submitted late, but it wasn't. In fact, it was a renewal of application in relation to 56A. The relevance of this is all, as you will have heard in tranche 2, Andy Coles gave the name of a civilian from 56A on his arrest when he was arrested, the arrest that led to his departure and exit strategy. So the name of that person is relevant. He is not part of the restriction order. There are one civilian and two core participants who are, and so we do need to get to the bottom of this. I haven't seen the questions that have been asked of 56A, but I do have the disclosure.
So you've lost me completely.
It is as confusing as I set out. There are.
But 56A is not a core participant.
No.
Nor is it going to be. The individuals who may or may not have had something to do with 56A have received requests for witness statements. You do not represent them. What's the problem?
I have the disclosure in the capacity of 56A as a civilian group, and I've been advising 56A for some time, two core participants and one civilian who's not part of the inquiry. The problem is that there are two firms who are instructed, and we just need to get to the bottom of it. And I think the application is for more time while this is resolved, because we hope to get to the bottom of it with the inquiry. But the Rule 9 request was only received towards the end of last week with a deadline for early April, which is 3 weeks away.
Rule 9 request to whom?
To Carolyn Wilson.
Who is represented by whom? Hodge Jones
and Allen.
Then I don't begin to understand why this is a matter of concern for you.
Well, I've got the disclosure, and I'm liaising with the civilians who are involved in 56A and who are on the restriction order for 56A.
If this is, you're not instructed by Hodge Jones and Allen,
no.
Who represent the individual from whom a witness statement has been requested.
No, that's correct.
I don't begin to understand what standing you have in this particular matter?
Other than that, I've been assisting 56A InfoShop, a civilian group, and received disclosure for them, and dealt with privacy reductions in tranche 2, and had conferences with the relevant people, one of whom is a civilian who is involved in 56A InfoShop.
I will pause for a moment while I attempt to get to the bottom of this with my team, but my current understanding is that there is no decision that I need to make about this issue at all, but let me go and ask them.
Well, I think the issue, sir, is the deadline for the witness statement that has been submitted with it, which, as I understand it, is early April.
Witness statement by
Carolyn Wilson.
Well, but she is a Hodge Jones and Allen client, not your concern. Anyway, let me go. I'm going to rise to attempt to get to the bottom of this.
Yes,
Yeah.
sir.
I'm afraid that you have no standing in this matter, and any application will have to be made, if there is one to be made, by those who represent Carolyn Wilson.
Well, then, if I could just say that Mr. Greenhall is here, so he may wish to renew the application that I've just made to you, bearing in mind what I've just said, that when the date the Rule 9 request came through.
I'm sure he can hear what you say. Right.
Thank you, sir. Thank you.
Thank you. Now it is, I think, Mr. Scobie, is it not?
Yes. So I hope this is going to be relatively straightforward.
Yes.
Because it relates to a single extension for Lois Austin. It's the reasons are set out for it in paragraph 5, amongst others, in our short note dated the 14th of March. Essentially, and the court will know this well, so you'll know this well, the position is that unfortunately Mr. Heron has not been 100%. Far from it.
I've seen that, and I make allowance for that.
Yes, and so we are hoping that you'll grant the extension sort, which is until the 3rd of April 2025. There have been others extended, but the lengthiest one is actually Mr. Nynham for I think the 9th of April, but all are going to be done by then. We would ask for the 3rd of April for Lewis.
Agreed.
I hope I anticipated, sir, this will be relatively straightforward.
Yes.
Morning. So that's all we have to ask for.
So as far as the remainder go, the clients represented by public interest law, am I being invited to do anything?
No, you're not. So we are more than content with the extensions that have been granted administratively. I just wanted to say to you, sir, that there is actually one dated after the 3rd of April. No extensions are required beyond what's already been granted, and we're very happy with what we've got.
Thank you. In which case, that makes my life and actually today yours easy.
It does.
Thank you.
Thank you very much.
Thank you. Now, I think we've now reached the point where either I should hear from Mr. Morris and Ms. Steele if they're ready, or alternatively, if those who've been taking instructions or either of them are ready, from them.
So if it assists,
yes,
instructions as to the dates of deadlines sought.
Yes,
I represent.
Yes. See, forgive me, your voice got lost in translation. Say it again, please.
I'm sorry, sir. I now have dates for the extensions sought for all those I represent, if it would assist from me now.
Then it would be a sensible course for me to hear your submissions on those dates.
Thank you, sir.
I'll do that now.
So given the approach you've taken thus far, I wonder if I might revise the order in which I wish to address you.
Yes.
To preempt any questions. I ought to say, sir, well, I ought to begin by asking whether you've had sight of our document dated the 14th of March 2025, in which some of the reasons for the extensions we seek are set out.
I have a long document dated the 14th of March.
3 pages, sir. It ought to be just to...
Then let me just check a moment. The date again, please.
14th of March, sir.
14th March. I don't believe I have.
So could I just interrupt briefly? Yes. I think the document that my learned friend is referring to is the one that you will find in your supplementary bundle at tab 5, page 49.
Right. I do have that. Forgive me, I have got that. Thank you very much indeed.
Thank you, sir. I ought to say, as a preliminary matter, Miss Steele is in the room with me, yes, on a different laptop. The reason for that is that she and I had some time ago set aside this entire week to work on her witness statement. We did so yesterday and made considerable progress. I give that as an example, a case in point for a general observation of the proactive approach taken by all, and I emphasize all, whom I appear to represent today. These applications are made in the spirit of engagement and providing realistic estimates in the hope that they may ultimately save time. So you will, of course, be aware that it goes without saying, the people I represent are represented by the same team. And so while it might be reasonable for one team to do one statement in a certain number of days, there are other logistical factors to be put in play. As you've heard so eloquently said by others ahead of me today, people with lives, jobs, caring responsibilities, and then a team that must manage those deadlines as best they can. I emphasize this, sir, to make the point that we do not make these applications lightly. Excuse me a moment. I'm so sorry, sir. I have a cough, so I may mute myself in the hope of avoiding passing it on. It is also, I hope, self-evident that, in particular for the Category H core participants, the process of providing these witness statements is extraordinarily traumatic. The inquiry has, as part of Tranche 2, already had expert medical evidence from Dr. Mike Kozinski on the impact of an approach that places adherence to deadlines, or appears to place adherence to deadlines, ahead of trauma sensitivity on at least one Category H core participant, and it is not, in my submission, unreasonable to infer similar psychological harm might arise to other women if a trauma-informed approach is not taken. I understand entirely, sir, the observations that you've made earlier in this hearing about the need for practicality and the extent to which the inquiry's hands are tied by its terms of reference. But I make the point that well, bluntly, sir, deadlines that are not achievable do not become achievable simply because they remain. The wish of all of the people who I represent today is to be able to give their evidence to assist in this inquiry that many of them are responsible for bringing about, and they are desperate to engage as well as they can. Turning then to the individual applications and starting with Helen Steele, who sits in the room with me. Excuse me. So Ms. Steele, you are aware, found the process of writing previous statements extraordinarily difficult, and the one that she writes now is the one that is likely to be most traumatic for her, relating as it does significantly to her relationship with John Dines. She has had some 1,600 pages of disclosure in relation to Tranche 3 alone, as well as, of course, the many times more than that she had in relation to Tranche 2. She also has significant privacy reductions. Forgive me, sir, I ought to say, of course, Tranche 2 material remains relevant to her because of the need to address her relationship with John Dines. She has significant privacy reductions to consider, both in terms of her own statement and in terms of the documents that have been served to her. And given the shortness of that deadline, or the proximity of that deadline, I ought to say, that, of course, will be a priority for her alongside writing her statement. I appreciate that the 6th of June, the deadline for which Ms. Steele asks, is the longest deadline for which you've been asked today. But in my submission, sir, in particular, in light of the evidence that you heard in Tranche 2 from Dr. Kozinski, hers is an exceptional application. And given the impact that we know from experience, as well as from Dr. Kozinski's report, that short deadlines and pressure have of making it substantially more difficult for Ms. Steele to complete her statement. In my submission, that exceptional application is fairly made and would be fair to grant.
As you acknowledge, this is an application for an exceptional length granted in relation to an exceptional statement. Please explain to me why a witness statement cannot be prepared within the sorts of time frame that I have been discussing with others up to now.
So precisely for the reasons that I've set out in relation to Ms. Steele's trauma and the impact that it has on her ability to engage with the material, as well as, of course, the exceptional volume of material that is particular to her case, given the range of issues that the inquiry is exploring in which she is engaged. So the volume of the material and the particular way in which the trauma impacts her, which is to say that pressure makes it extraordinarily difficult for Miss Steele to engage, and the only practical way for Miss Steele to be able to draft her statement is for her to have space, for her to have breaks, for her to be able to take considerable time and to approach such matters as she is able to when she is able to. And I stress that I don't make this application lightly. I make it based on the medical information that we have and based on experience of working with Miss Steele on her witness statement so far. I absolutely have no desire to give evidence, but so you can imagine, I'm sure, the wish of all involved to ensure that this statement is completed and is provided to the inquiry, and of course to ensure it's done so in a timely manner that allows the inquiry to properly prepare and the inquiry legal team to properly prepare. But in my submission, a shorter deadline runs the risk, as we know from experience, of making it impossible to provide a statement at all, which in my submission is something, a situation in which the inquiry would be considerably poorer.
But as you will be aware, a substantial part of the statement that she will make covers material that was disclosed to her a very long time ago now. Everything in relation to Dines, both the contemporaneous reporting while he was deployed, and as I understand it, that which was created after he left these shores and while she was looking for him. Am I right in assuming that she's had those documents now for very much longer than would ordinarily be the case?
So some of them, yes, although of course they came through piecemeal. That's not a criticism, it's the nature of things. Some of them she's had for more time. Some of them are now only now able to be read in context of the statement that she now needs to make.
Right. But she's certainly had all of the documents relating to the deployment of Dines, has she not, for a long time now?
So I can confirm the exact dates with those who instruct me, but I take entirely the point that you make.
Yeah, I can readily appreciate that she needs time, has needed, and perhaps still does need time to read into and to respond to the documents which concern her efforts to try and find Dines and what was done on behalf of the Metropolitan Police to protect him. And that is an issue in itself, on which I would welcome her evidence, but I've also got to examine the evidence of the operation to deal with her research into Dines and to protect him, and the effort and sums of money that were spent on that.
So yes.
And these are significant issues that I've got to address in due course. Now, as far as her relationship with Dines goes, I would have thought that by now that ought to have been in a position where it could be produced in short order.
So, excuse me. Certainly, some significant, if I can put it like that, progress has been made in respect of the relationship with John Dines. And I ought to say, traumatic as Miss Steele found the last tranche and giving evidence as she did in the last tranche and the need to prepare her statement and prepare herself to do so, she nonetheless took less recovery time than perhaps one might expect in order that she could begin working on this statement herself. So considerable work has been done. It is still not ready. Those two things are true at the same time. And the reality, unfortunately, is that the subject matter of the statement makes it significantly harder for her to engage with and to draft than perhaps, for example, previous material might have been, even knowing what we know about how difficult she found it to engage with, for example, allegations made against her in the past, which though not of such an intimate nature, she still found extraordinarily traumatic to have to deal with. So this is the most traumatic thing. So if I can put it shortly, it's the most traumatic evidence she will give.
I readily understand that in relation to her relationship with Dines while he was deployed and her decision to try and find out what had happened to him. One of the things I'd like to raise with you, and I haven't discussed this yet with my team, but I want to raise it as a possibility so that we leave no stone unturned, is would it be possible to produce two statements, one relating to her relationship with Dines during the time that he was deployed, and the second in relation to her efforts to try and find him?
So, interestingly, that is precisely what Miss Steele and I had described doing yesterday, or had discussed doing yesterday.
Yes.
And certainly, I'll confirm my instructions. She's in the room. She hears this.
Yes.
But certainly that was an approach that she felt would be helpful when we discussed it yesterday. So it may be that we're in agreement on that.
I merely floated as an idea upon which I have not yet gone back and taken instructions. But if that were to be done, are you able to give me an indication as to when the first of the two documents could be produced?
So I need to take instructions from
Of course.
that. Perhaps while she gives that matter some consideration,
Yes.
I will address you on the other Category H and Category J core participants.
Of course.
Thank you. So moving then to the woman referred to as Lindsay, her current deadline for her statement is the 19th of March, so tomorrow.
Yeah.
Lindsay is a single parent. She homeschools her child. She is also, in what little time she has left, a carer for her elderly mother.
Yes.
As well as working to support her family.
Yes, I have read the personal details, and if there is any difficulty about referring to them on an open screen, you can take it that I have read them and I do know what they are.
I'm grateful, sir. The other point I wish to make, forgive me, about Lindsay's case in particular. Excuse me. But it serves by way of example of some of the technical difficulties that we have had.
Yes.
A request was made in Lindsay's case on the 14th of February for permission to download certain documents because she was finding them very difficult to work on. They weren't searchable. She had limited time to work on them when her child was doing activities and her mother didn't need her. That was not able to be approved by the inquiry until the 28th of February. So that 2-week delay in approving that request cost Lindsay considerable time as well. I only mention that, sir, because it's not something that's in the written application that we make, but it's something that in my submission weighs in favour of the granting of the application in her case.
So, and the application in her case is until when?
Until the 14th of May, sir.
From what I know, there would be no difficulty about the 2nd of May, but there would be beyond then.
Well, so as I said at the outset, and I don't propose to try your patience by repeating on every submission, but each of these dates is considered by those who instruct me and by my lay clients to be the earliest realistic date by which they can provide the statements. These are not arbitrary numbers that are being offered.
Granted, but the documents that were sent in before today's hearing were all talking about the 30th of April.
So I may need to confirm my instructions on perhaps you'd allow me to come back to that point, sir.
Of course. But at the moment, you may take it that I would have no difficulty with the 2nd of May, but anything beyond that would or is likely to require particular circumstances which make it, in effect, imperative rather than merely desirable.
So yes, I'm confirming. I'm seeking to confirm my instructions because the letter I have in front of me doesn't have, in which we make our formal application, doesn't have the exact date. But I'll
no, but the document that was sent on behalf of all, notionally on behalf of 92 individual core participants, including Lindsay, I think, spoke of the 30th of April.
I understand. Thank you, sir. So turning then, if I may, to Ellie. And again, so I don't wish to repeat submissions you've already had. She is addressed, and her circumstances specifically are addressed in the letter sent to you on the 14th of March by those who instructed.
Yes, I think it would be sensible, unless you persuade me otherwise, to deal with the 3 female participants who interacted with HN16 together. I assume you want to deal with them all together.
So I had proposed to deal with them separately because they have separate circumstances, and some are able to offer shorter deadlines than others.
Yes.
So in respect of Ellie, the deadline, the extension she seeks is the 12th of May, which I appreciate is not much shorter than the 14th, but I feel I have to make that point, 2 days shorter than the 14th.
Okay.
So the reasons for her particular application set out in the letter, I don't propose to repeat them unless it would be assisted.
No.
So there is an application in respect of Donna, but if I may, I wish to make that application in closed session.
Yes.
In due course. And I say aloud for Miss Steele's benefit, I may have to ask her to leave the room while I do that. Turning to the others, Wendy, who is mentioned in our letter, but no reasons are given, I can provide all reasons on.
Yep.
Her current deadline is the 11th of April. The deadline sought is the 23rd of May. Wendy has 2 part-time jobs and a regular commitment on average every 2nd weekend. She is, as a result, finding it extraordinarily difficult to find substantial chunks of time as she requires to work on her statement. She's found reviewing disclosure on EPIC difficult, for example, having to close one document to cross-refer to another has been something that she's found it quite difficult to navigate, and which I think all of us can empathise with, having experienced those early days of EPIC usage ourselves. Having reviewed her disclosure, there are now matters arising out of that she wishes to review, to request further relevant disclosure on. And she's also currently attempting to work on a simultaneous deadline in ongoing and related legal proceedings. There is a time difference, and I can seek instructions on the exact number of hours, but I'm instructed, a significant time difference between the UK and Wendy's country of residence, which is, of course, a further factor that limits the available time she has to engage with those who instruct me.
You say that she requires to see further documents. I will obviously ask my team about that, but in general, the position is that all documents which the inquiry considers that an individual needs to see and which it has in its possession are sent to them. And requests to see other documents before a witness statement is provided are not likely to succeed. So that can be put to one side.
Understood, sir.
And does that affect the time?
So I'll await instructions. I don't believe it will. It will be because that was supplementary information that was provided to me, if I can put it like that.
Yes. Okay.
Turning then to the application on behalf of Sarah. Her current deadline is the 11th of April, and the extension sought is until the 23rd of May. So Sarah has very recently suffered a very close bereavement, requiring her to take significant time off work. While she has now returned to work, the emotional impact of the bereavement, as well as the additional administrative burden of having to catch up on the work that she missed while she was away, has hindered her ability to make progress with her statement, both in terms of time available and in terms of, as you can imagine, sir, emotional capacity. So, sir, on those grounds, an extension is sought on behalf of Sarah until the 23rd of May.
Anyone else?
So in respect of Alison, you forgive me, I've received instructions this morning in various different formats. So
Yeah, of course. No, please don't worry. I'm not the slightest bit bothered about the need to do this, that, and the other during this hearing. We'll do whatever is necessary to arrive at decisions.
Thank you, sir. In respect of Alison, her current deadline is the 24th of March. The extension she seeks is only until the 7th of April. She has very nearly finalised her statement. But
the answer to that is yes.
Thank you, sir. Then I won't trouble you further. In respect of Monica, sir, her current deadline, excuse me, is the 11th of April. The extension sought is until the 16th of May. She is about to begin a new job. She wants to complete the statement before then, and so her application is made in, I think, in fear of not meeting the 11th of April, if I can put it like that. She and those who instruct me have worked enormously hard on her statement, and she again has made considerable progress. But there are substantial documents to work through, and as I've said, those who instruct me have 12 Rule 9 statements. They're all complex, and as well the significant emotional impact of the material that Monica is reviewing means that in order to ensure she can provide her very best evidence, she wishes to ask until the 16th of May.
Well, again, I will need to go back to my team, but the indication at the moment that I have is that there is no problem about the 2nd of May, but there are about dates later than that.
So that's understood. Thank you. So I have also been asked on behalf of Ms. McSherry, who instructs me, to address you briefly on 3 Category J applications for extensions. Ms. McSherry wishes me to pass on apologies for instructed counsel, none of whom are unfortunately available to attend at such short notice.
No, it was very short notice, but no conceivable complaint about that.
I'm grateful, sir. So I hope you'll forgive if my submissions are not as clear as they could be on category J. I'm not, as you know, not usually instructed for them, but dealing with them individually, if I may. Mr. Wadsworth, his current deadline is the 31st of March.
Yeah.
The extension request is until the 7th of May. Mr. Wadsworth has only been provided with certain documents in which he is named. He has not been provided with documents which name his organisation, Anti-Racist Alliance, and are therefore relevant to him. Mr. Wadsworth hasn't had confirmation from the inquiry that they do not consider those documents to be relevant to him. So he has been seeking access to those documents in correspondence with the inquiry. So I'm instructed he's been seeking access to those documents since the 5th of February. The last letter received no response, and so the matter remains unresolved. There are also 3 pages of the documents provided to him for which he has sought legible copies. That repeated request, I'm instructed, has also gone unanswered. There are also matters of a private nature that give rise to a request for an extension, which I can address you about privately, so if you wish. So he seeks an extension to facilitate the disclosure of these documents and to address the private.
Yeah.
The extension sought, I can't remember if I've said already, the extension sought is until the 7th of May. So turning then, forgive me, turning then to the participant known as NMP. NMP's current deadline is the 11th of April. They apply for an extension on their own behalf to the 9th of May 2025. The reasons given are as follows. First, that compiling a response to the Rule 9 is taking more time than it would for an individual, because while there's one point of contact who will sign the statement, there are 5 people reading the documents and contributing to the NMP statement, each with limited availability. The clients all work full-time or part-time with other important time-consuming commitments during the week. The only real time that they have available to work on Rule 9 is at weekends around family and other commitments. One of the NMP clients has been abroad from the 31st of January to the 3rd of March and will be abroad again for work unavoidably from the 19th of March to the 28th of March. So all of the clients are first-time users of EPIC and continue to struggle to navigate it. The fact that it's only possible to open one document at a time is causing them some delay as well. And finally, so they are consulting their archive for documents that may assist the Rule 9 process, but that process is taking longer than expected. And so the submission made on behalf of NMP is that for them to be able to participate fully and effectively in tranche 3 of this inquiry, they need more time to consider the disclosure, to collaborate, and to produce a comprehensive Rule 9 response. So the extension sought is until the 9th of May.
That, I think, is it, apart from Guy Taylor, is it not? Oh, that's been agreed.
So yes, forgive me, I think there is one more application in respect of Patricia Armani da Silva.
Yes, you're quite right.
Campaign.
Mm-hmm.
The existing deadline is the 7th of April. The extension sought is to the 30th of May.
Now, I readily appreciate that there are problems of a logistical kind with her for a whole variety of reasons that you set out. in relation to the deadline for submitting privacy applications, my expectation is that she will not be able to comply with that deadline. Am I right in assuming that?
I'm so sorry, sir. You cut out for a moment. Could I ask you to repeat?
Of course, when these glitches occur. The date for submission of privacy applications over documents supplied to participants by the inquiry is the 11th of April. My understanding is that the particular difficulties that face Ms. De Silva are such that she is unlikely to be able to meet that deadline, so that the inquiry team will have to do privacy applications on her behalf, come what may. Am I right in that assumption?
So yes, that's correct.
Yeah, I thought so. There's no criticism of her, because I know the problems under which she operates and the difficulties of dealing with this, but there are particular reasons why in her case I'm well aware that she can't comply with it, and so the inquiry team are going to have to do it. But the application for the witness statement is until the 30th of May.
So yes.
And again, there are particular reasons why, exceptionally, a longer than, as far as the inquiry is concerned, sensible or convenient deadline may have to be allowed, but I need to speak to the team about that.
So yes, thank you.
Now, does that deal with all of those on whose behalf you're making submissions?
So I need to address you privately about Rosa, if
Yes.
I may. I also need to address you privately about Donna.
Yes.
Will you forgive me? I think I'm just receiving further instructions as we speak.
Yes, of course.
So I wonder if now might be an appropriate moment for a very short break while I confirm those instructions.
Certainly, but in relation to Rosa and Donna McLean, are these instructions which relate to them or to others?
I'm not entirely clear, sir.
Very well, don't worry at all. Doesn't matter. Well, I will break for the time being for a short period to deal with the applications that you have made, where you do not need to make any private applications in addition.
I'm grateful. Oh, forgive me, sir. There's one point that I've been asked just before you rise to make.
Yes, of course.
You are considering in respect of Wendy.
Yes.
I'm instructed that the request for the 23rd of May is maintained, and that one reason which has not yet been put is that those who instruct me asked the inquiry to download documents on the 7th of March to deal with those problems that I've outlined regarding navigating EPIC, and that no response has been received from the inquiry yet. So it's a small point, but one I've been asked to make in respect of the Wendy submissions. If I can put them like that, then perhaps I can address you on other matters after a short break.
Of course. Well, I'm going to rise now for a short period. I'm not going to say how long it's going to be, because there are a number of individual applications that I must consider.
Grateful.
some progress has been made. I wonder whether you can come back on the screen.
Yes, I am here.
Thank you. Good.
I wanted to say as well, sir, there are certain submissions I would wish to add to in respect of Miss Steele in closed session, if I may. I only
Of course.
now, in case your intention was to give a ruling before I'd had the chance to do so.
No. What I wanted to say about Miss Steele was the proposal that she should produce two statements, one about her relationship with Dines during his deployment, and the second one about her efforts to find him afterwards. That is an idea which meets with favour in my team, and I hope that we can agree that is what should happen. And when I've heard you in private, we can fix the dates.
Thank you.
Can I deal with the other ones where you have made completed submissions? As far as Lindsay and Ellie go, I extend time until the 9th of May, Friday the 9th of May. As far as Wendy and Sarah go, because of the particular circumstances in which they find themselves, I extend their time until the 16th of May. Alison we have dealt with. Monica, I will extend time until the 9th of May. Newham Monitoring Project, I will extend time until the 2nd of May. Because of the particular difficulties and circumstances in which Mr. Silver finds herself, I will exceptionally extend her time until the 30th of May. But it is to be understood by those who succeed these submissions that is because of truly exceptional circumstances which cannot be surmounted before that date. I think we've now reached just after 1 o'clock, when it would be a natural time for a break. I will hear your submissions in private. Would 2 o'clock be convenient for that?
Thank you, sir. Yes.
Then we'll resume, but in private and not on the live link at 2 o'clock.
And will we speak after that private hearing?
Certainly we will, yes. Don't worry, this is merely to deal with these private matters,
Okay.
and there are then other matters I've got to deal with openly. Not least your own application.
Thank you.
Right. Then until 2.